Good afternoon, everyone. So excited to be here today. We have a guest speaker that we have brought from the plaintiff side of the fence who can talk to us about the types of things that he is seeing most often in his employment law litigation and his firm's employment law litigation. And so we have a great presentation for you today. We're going to talk about the pitfalls, what employers get wrong, even when they get it right. And my conversations with Jake have been that there's some relatively simple things and they align with the things I see. So we're excited about this today. Next slide. You can go ahead and slide through, and I'm going to talk about Jake. The way I came about recommending Jake to join us, and so stay on this slide, is I was involved in a case with him and realized his history and realized he had a lot to share. So Jake actually started out on my side of the fence, our side of the fence, as an employer's lawyer and defending employers in employment-related matters that would be brought by their employees. And he was actually at Hainsworth Baldwin Greaves, which was, we're Hainsworth Marion, and that's Hainsworth Greaves. There's a relation there from a familial relation, and he stayed there from 1990 to 2004. So he worked on that side of the fence for employers handling discrimination cases, wage and hour cases, a bunch of collective action cases. When they merged with Ogletree, he was then employed by Ogletree, and then eventually he jumped the fence into in-house counsel and became corporate general counsel and deputy general counsel for two corporations. And during that experience, he was working with employers in the capacity of advising them how to communicate and deal with their employees, but the employer was his client. He was then put into the capacity of leading the HR group. He became the leader of the HR group as an attorney, and he did that for 2 years. He said that was one of his favorite jobs because he learned about benefits and how to restructure benefits to the benefit of the company. And he also dealt with team relationships and other things that would be impacted from an employment standpoint. So and now he's in the plaintiff's side. He came back to the plaintiff's side in 2015, but before making a quick stop at another defense firm, Littler Mendelson. And now since 2015, he has been a plaintiff's employment lawyer. And so when I figured that out, I thought this person is going to be able to give some very helpful advice to our attendees. And so I asked him when we were wrapping up our case, and he agreed to do it. So as always, if you've got questions, put them in the Q&A or the chat. Make this an interactive opportunity because you have opportunity to talk to Jacob Modla from Cromer Babb, and many of you who have been employers in South Carolina for a while are not unfamiliar with Lewis Cromer and the Cromer Babb firm, and often find them bringing claims against you. Hopefully not too often. We certainly deal with that firm a good bit, and so this is our opportunity to ask some questions, which is why we sent out the email beforehand, and we've got those questions. But go ahead and put those things in the chat box as they come up. Jake and I are looking forward to tackling whatever you've got to serve up to us. And with that, let's get going. All right, Jake, kick it to you.
All right. So, as the slide says, it's not always what you say, but how you say it that counts. That's an old adage that we all heard growing up, and you can advance the slide to 5. As a plaintiff, as someone who's did defense work and now who does plaintiff's work, the greatest source of ammunition for a plaintiff's lawyer has been and continues to be email and text communication. It's the gift that keeps on giving to the plaintiff's bar. And as that second point B states, managers and decision makers continue to treat email as a relaxed form of communication. And I sometimes wonder, do managers even realize that their email and their texts are discoverable? I know when I was in-house for 8 years at Family Dollar stores, we did training every year just trying to remind people that, hey, this stuff is discoverable, and it never took hold. I would continue to be disappointed in what my colleagues would draft, and now that I'm doing plaintiff's work, it really is a huge driver to make cases for the plaintiff's bar be very successful and lucrative. Um, you can go ahead and advance to the next slide. A lot of the problems stem from the fact that the emails and texts continue to be filled with incomplete sentences, undefined abbreviations, incomplete thoughts, and the worst sin is the poor attempts at humor. Um, and then many times you see managers are allowing messages to be sent in the heat of the moment without the benefit of reflection or deliberation. It's just a knee-jerk way to communicate, and it comes back to really be painful for the organization if you're ever challenged in like an EEOC inquiry or in litigation. You can go ahead and move to the next slide. And I wanted to share a couple examples of just how painful these things can be. So the first one, Merry freaking Christmas. So when I was with Family Dollar Stores, we tried a 2,700 member class action. It was a managerial exemption case. Were our store managers exempt? And our argument was they were. They ran their stores. They ran this little box called the Family Dollar Store, and surely they were exempt. And we tried it twice. The first time we tried it to a hung jury, and then we had to go back and try it a second time. And in the second trial, during the trial, up on a big screen in the courtroom, the plaintiff's lawyers put up an email that one of our district managers, the next level of management above store manager, wrote. And the title was Merry Freaking Christmas. And it was a very short email, and it said, if I'm working during the Christmas holiday, you are too. And I don't want to hear one word about how ready you think your store is. I'm telling you, you're all working throughout the holidays. If the store is open, you're working, period. And that one email, when seen by the jury, just washed away any presentation we had made that our store managers control their store. They decide when they work, they decide what happens. But when they saw Merry freaking Christmas, we were in a world of hurt, and we got popped to the tune of $28 million in that case. That was the jury verdict. And then we took it up on appeal to the 11th Circuit, and by the time, the post-trial interest finished running, it was pretty expensive. I've got another one up there that talks about out with the old, in with the new. And this is another example of an email where a company that did engineering wrote an email to the greater group of managers that said, we have young engineers in the pipeline, and there is a desire to use the young engineers in the future. That's our desire, to use these young engineers. And that was it. Well, after those two emails went out, over the next 10 months, 4 50-year-old engineers went away, and they were replaced by 20-year-old engineers. And so when it came time in the H case to go to mediation, that was a very powerful tool. It was like a cudgel being beat over their head over and over, because again, there was no context other than we've made the decision to use these young engineers in the pipeline, not the more qualified engineers. Nothing about what made them special, just this, they're younger, so that's what we want to do. Got another example there, don't mix physical disabilities with job elimination. We had another case where in mediation, company wanted to claim that somebody with a disability, their job was eliminated for legitimate business reasons. But on the day of the elimination, an email was sent. And the email asked questions like, did he provide you with any information about his prescription drugs when you spoke with him? What did he tell you specifically about his MS? Did he use a cane during the interview to walk around? And then there was a back and forth about an inability to provide a urine sample and thinking that was somehow related to the disability. It's very hard to, and that's it. There was no discussion about why they were having these questions discussed on the day of a so-called job elimination. And so again, that email became a very powerful tool to drive a settlement. And the last one I want to talk about is probably the most extreme example of how costly these emails can be. A friend of mine tried a case up in Charlotte recently. And in the case, it was about a bank executive. And he worked for one of the larger banks in the country, and he worked from home. And he had a real bad disability that dealt with his digestive system and his ability to use the restroom and the frequency in which he needed to use the restroom. He had been working home for a number of years and wanted to continue to do so. And for some reason, the bank decided, well, we don't want to allow that. We want you back in the office. And there were these very contentious discussions about um, allowing him to work from home or trying to get him back into the office. And around that same time, on December 1st of the year in question, they were doing a mass job elimination. But the jobs to be included were closed on December 1. 6, 7 weeks later in January, they opened the list up and added him to the list of jobs to be eliminated. So at trial, they argued to the jury his job elimination was no different than all these other hundreds of job eliminations. So that's our legitimate non-discriminatory reason of why he's no longer working. It had nothing to do with his request for this accommodation. Well, the problem is on the night that he was put onto the job list of people to be let go, an HR professional sent an email about 10 o'clock at night that said, mission accomplished, he's gone. Now, talk about silly. Why would you send that email if this was some legitimate inclusion of his job in the elimination? The jury just would not buy their story that there was nothing inappropriate about it. And so they found that he had been fired because of his request to have his disability continue to be accommodated by working from home. And because he was a highly compensated individual, it helped support a $20 million jury verdict. And none of that was punitive. It was all back pay and some front pay. And so the case is now up on appeal, but they really don't have a lot of grounds because the case was tried in front of a former chief judge. And so one ill-advised, silly email that served no legitimate purpose at 10 o'clock at night about mission accomplished, he's gone, cost them 20 million bucks. And it looks like they're going to pay, and they're going to pay more because of what happened to me when I was at Family Dollar. That post-judgment interest is going to run. And so I'm sure the check they end up writing is going to be a lot bigger than that original $20 million verdict. You can go ahead and
No,
advance the slide.
no, those are all great points that you're making, Jake. And I personally have also had a situation where a supervisor's really snarky communications in an email ended up resulting in us having to settle something we otherwise wouldn't. I actually had a whole file of these emails that I used as training. I would obviously de-identify them. And one of my law partners took it to use with one of her clients, and she let all the originals go. So I was glad Jake had some good examples. So let's go to the next slide, and then we will also shoot a poll to y'all that's specific to the good help, the good topic that Jake has just covered, the importance of communication. And Raven, you can just tell me when it's okay for me to go ahead. All right, so the answers to the poll. This is great. The question is, have you received training on effective workplace communication? Yes, have said 60%. No, said 40%. Well, I am encouraged, honestly. Aren't you, Jake, by that percentage? I would have thought it was less.
Yeah, no, I think that's great. I mean, I think
Yeah.
that's great because workplace communication, there's like, as I've previously said, there's no better way to get folks going to see a plaintiff's lawyer just to talk about what happened to them than a failure to communicate. I can tell you in the last year, at least on 3 or 4 occasions, I've had people come in, pay a consultation fee because when they got fired after several years of employment, they were told it's an employment at will state. I don't need to tell you why you're being fired today. That's
That's
not
right.
effective communication.
No, it's not. And, I'm going to say, the managers, employers, executives, everybody, they're all human, right? And I think what happens is people get frustrated at a certain point. They've given somebody every single chance to succeed, and they're just up to here with it. I've even been that way before myself. But the problem is, um, the jury never sees it that way. The jury never looks at this corporation as a group of individuals just trying to get along, managers just trying to do that. And this person over here, it was just, the same level. Never sees it that way. And trying to convince employers to understand that when they're frustrated and are making decisions at that point and not realizing what it looks like on paper and just optics of the decisions and the way they're being delivered. I've had a lot of difficulty convincing employers about the message. The message can be the same as how we deliver it. And so Jake and I talking about this had me kind of revise some training tips I have that I include in my my management training, which I think is key. I like Jake, think the most important thing you can do is train your managers. There's the boots on the ground. No policy or compliance effort is ever as good as what your managers are saying to your employees. So the folks at the bottom level of the first level of management, those are the ones, if they're not trained, then, then your things are against you before you get started. So Jake said this, and I stole it from him, put it as my number one with his permission. Train your managers on how to have hard conversations. No one likes to talk to people about, number one, they're not performing well. Number two, they're about to be fired, and anything in between. And, HR tends to be really good at that, or should be. So in a situation like that, the fix is HR needs to be present for these conversations. That's typically my recommendation, and documenting it. But you can't always do that. A lot of these places are 24/7 and HR is not there. So this training is so crucial. In my training for managers, have focused now more and more on this. So how to have the hard conversations. And, are we telling our employees, as we're seeing them not improve after they've been trained on how to do something, are we saying, hey, just need you to do this, just need you this? Or are we waiting? Are your managers waiting until they're angry and uncomfortable? Well, that's going to be hard to have communications, and that's going to be true of the executives and everybody. Act sooner. So number two is training managers on how to have those conversations respectfully. Jake was touching on that. He was touching on that. Yeah, look, we can message what we need to message, typically, not the out with the old and with the new. I'm having a hard time spinning that in a good way, Jake. But we can generally message what we need to message in a way, say the same thing, but deliver it in a way that doesn't feel like somebody has just been treated horribly. Because generally, the way we communicate in life as well as at work matters, and it has more of an impact than what we're actually saying sometimes. So if you want something to be heard and understood, treat people respectfully and with dignity. Train your managers to communicate with their employees firmly and frequently if needed, while treating them with dignity. So we don't wait until we're just up to here with something that we're seeing. We're dealing with it as soon as we see it. And we're addressing it from the outset. And we're also giving our employee every chance to succeed. We went to all the trouble to get him here. Let's give this employee every chance to succeed. Train your managers to know when they need to begin documenting performance, conduct, and attendance. That continues to be the thing, an area where I see the most problem, where we're not having as good of documentation as we would need to defend ourselves in front of the EEOC, the Department of Labor, or a jury or a court. And so a lot of them don't want to document. A lot of them want to tell the employees nice things and encouraging things until they need to let them go. That happens everywhere, and it is a death knell to employment law litigation. It just is. So documenting performance, conduct, attendance, and dealing with it early. And that's where HR needs to be popping in, because they know how to have these conversations. So the other thing is, you've got to train your managers to get to HR and run stuff by HR. Next slide. So this is a 2-slide manager communication training that I am providing that I would encourage you to use with your managers. And it is what I use in my management training. And it's just giving them the framework. These are good, just normal questions. Leaders set the example of respect and civility. If they're not respectful and civil, then the employees that work and direct reports that report to them will believe they don't have to be either. They'll also see how the leader is handling the communications, and they'll take a note. And often the person who is taking a note and is going to bring it up in a claim later will never say anything. They don't feel comfortable saying anything. Leaders can't be conflict adverse. Now, we're all conflict adverse. Nobody wants to tell someone they don't want to hear. But that has to be overcome in a leader. And if a leader knows that they can't do conflict well, then they need to align with someone who can help them do it. It's important to direct reports employees with dignity. I've said this, I can't say it enough. Employees who feel respected and safe in their jobs are happier, and they're typically more productive, and they're typically more responsive to managers. It increases the respect for the managers and the company, which will increase productivity and top-notch performance. They want to do well for someone who treats them well. This is just common sense. And they're more likely to raise issues that they're concerned about with the manager before they become liabilities. And that makes the manager look really good to the top level folks because the manager is stepping in a preventative way. Next slide. So, a self-test tool for managers. How do I approach situations that are tense or require conflict? Do I wait till I'm angry to address an issue? How do I respond when I'm stressed, busy, frustrated, or angry at work? Do I know how I'm coming across and how my behavior is impacting others around me? Do I praise when praise is due? Do I recognize successes? Do I communicate expectations? Do I give my employees enough understanding of what they need to do well? Do I talk to them about that, or do I just immediately start expecting after one discussion about what's expected? Can my direct reports trust me? Do I do what I say I'm going to do? And when I'm wrong, do I admit it? Do I apologize? Do I share this with my staff? I think so many people think, oh, I can never apologize. I mean, I've even been told that by folks, oh, never apologize, never apologize. I totally disagree with that. Strength is someone who can apologize. And I think that goes a long way to saying, I'm in this with you. Let's all get this done together. We all make mistakes. So next slide. Here is page 2 of the manager. Next slide, Raven. Page 2. Oh, there is no page 2. So I apologize. I thought there was. I don't know. Are we ready for another poll, Raven, or are we good?
Yes, this would be a good time for a poll.
Okay, Raven's in charge of the poll. I guess y'all can tell. Let's have another poll before we get to the other common issues. Okay, the question, has your workplace instituted a return to in-person work policy? All right. Yes is 28%. No is 25%, and 46% say not applicable. And that may be because they never had a remote work policy. So workplace instituting return to in-person is greater than those who have not.
Right. And I think that, the key takeaway here from this slide where we're talking about, return to work and its interaction with the Americans with Disabilities Act, and what I, as a plaintiff's lawyer, continue to see is that, employers have the obligation to engage in the interactive process, to have that dialogue where an employee comes forward and says, well, I need to continue to work from home. Y'all want me back in. I want to continue to work from home. But the real keys are, if you engage in the interactive process, you need to document what you did. what was considered, if it was rejected, why was it rejected? Because I think in the last year or two, at least in our office, we've had a lot of employees come in and say, listen, I've been working from home for the last 2 years. And all of a sudden, I'm told I need to come back in the office. And I don't understand that. I've got these medical conditions that my doctor's saying I've got to stay home. And in many cases, the employers, like point B talks about, there's a lack of explanation about why, what's changed, and there's a need to come back in the office. And so then these employees are running to see an employment lawyer, a plaintiff's employment lawyer, to help them preserve this work from home accommodation. And many times the situations we see are kind of what's outlined in C. The employee's just told, listen, Monday you got to be back in the office. I know you've been working from home for 2 years, but we just really want, senior leadership feels like we will be more productive. There's no discussion, there's no demonstration about, well, we've not been productive and we've got problems and we need to change. This is what's happened. It's just, we'll see you Monday. And, there's some case law floating around from 10, 12 years ago that I keep seeing cited that mention that the ability to be at work and show up every day is an essential function of a job. Well, that might have been before COVID. That case law might have been fresh, like a rose bouquet before COVID. But post-COVID, where people have worked from home for 2, 3 years, and they're staying in the same job, and now you just want them in on Monday, and then you can't explain any other reason for a change, is going to put you in a bad place. And what I see a lot of employers trying to say is, well, you need to be in here because you've got to lead your team, or you need to be in the meetings, and we need to have these productive meetings. But in the age of Zoom, it kind of falls on deaf ears because, lawyers, we have oral argument in front of federal judges using Zoom or WebEx or other technologies. During COVID, we tried cases using Zoom or WebEx. So the ability to do things remotely really undercuts and destroys the simple argument that, hey, we really need you here to be an effective leader. So I think at the end of the day, if you want to bring your people back in to the workplace, then I think before you pull the trigger and maybe send a few employees to go see their friendly neighborhood plaintiff's lawyer, spend the time as a group to come up with a crafted message that's loaded with factual data about why do we want to see people back in the office. And I think if you spend a little time, it's probably not hard to craft that message. But if you don't do it from the outset, then it looks contrived if you come up with this data later. Okay, it's not as clean a presentation if you're trying to defend yourself. You can go to the next slide.
So I think that's great points. And I want to just jump in here, Jake, and add that clients who permit remote work, I am reminding them to put provisions in that, first of all, protections for the company and what's expected. You're expected to be available and responsive during these times, et cetera. But also that if the employer believes the employee is not performing as well as they should, then the ability to work remotely can be taken away. You put all those protections in your remote work policy, and then you document why an employer believes the employee is not performing well that has made this request, and that will protect the employer at all times. Because otherwise you're stuck with doing undue hardship about why we can't grant this. And unless you're standing at a machine and running the machine, and there's, I'm sure, other jobs, obviously, that you have to be present to do. But it can kind of be hard to make that argument of undue hardship, which is Jake's point, if you've been doing it and they've been doing it effectively. So it kind of does go back to what did we document about this particular employee's performance?
And I think what I've seen is that many workforces that allow people to work from home for a period of time really fell off on their performance reviews. Okay, it's like they're working from home, so we forgot to fill them out or do them.
Yeah.
And to this day, I know when I was in HR, the big push was if we're going to do performance reviews, we have to have metrics that we measure performance and they have to be measurable. Okay, let's have more objectivity versus subjectivity. And because people have been working from home, that's fallen by the wayside. And it puts you in a inferior position to try to argue, well, they weren't as productive. I mean, if you have proper performance reviews in place that have objective metrics that can be measured, it should be pretty easy to show that they're not performing from home. Okay, they aren't performing the essential functions, and then you can address those folks that are working from home, and you might want to end it because you're not getting the bang for the buck that you want to get out of those employees. But don't make it easy for people like me, to attack those decisions because you can't defend the poor productivity. I think on this next slide, um, what I wanted to try to address here is another area where we see employers getting in trouble is with communications surrounding leaves. I kind of call it the iron triangle of workers' comp, FMLA, and ADA. Many organizations don't view those as interconnected. And when you have somebody injured at work, it's a comp injury, and you've got a certain group of professionals who deal with comp claims doing all the communication at the beginning or during the, when the injury is fresh, and they're not as tuned in as maybe some other HR professionals or leaders about FMLA and ADA. Well, the FMLA and ADA is part of that dialogue from day one, but the folks who administer comp don't necessarily remember that. And so you end up with a lot of statements like, we don't have light duty. Uh, you can't return to work unless you're 100% cleared to return, with a clean release by your doctor. And that's simply not the case. All right. I mean, the ADA is out there. The ADA applies to temporary conditions. You might have to do some accommodation while they're healing. And so I think it's very important that organizations again, trained to make sure that anyone who deals with workers who are injured understand that there's three legs to that stool. There's the workers' comp laws, there's the FMLA, and there's the ADA. And if they're not masters of it, you need to have someone well uh, advertised within the organization as kind of a subject matter expert they can go to get some feedback and guidance so you don't make mistakes. And I also think that what I see is a lot of companies have outsourced their communication and their leave administration to third-party providers. But I
Mm.
get the impression that many aren't auditing the performance of those third-party providers. I have a client or had a client last year and she had some chronic illnesses or permanent conditions. So she was protected under the ADA. She needed intermittent time off. She had a lot of challenges, and she would put in for time off, and she would get a letter saying you're approved. Then 10 days later, it'd say no, you're declined. Then 14 days, say oh no, you're approved. And it was almost like the person at the third party administrator had schizophrenia, and they just kept sending out letters that there was no rhyme or reason. And the company really didn't clue in till I got involved. And literally, you had about a foot of paper of similar letters just jerking her back and forth. And it led to a situation where then the company would get noticed that maybe she hadn't been approved. They're disciplining her for missing work when in fact it had been an approved leave. And it created a situation where, the company did not have a clean defense. They ended up having to put some money towards something to settle it. That if they maybe had just been paying attention to the quality of what the third party provider was doing, they could have avoided that completely. So I think, the big takeaway is, you got to document your leave communications, you got to document your interactive process, but you also need to make sure that your team understands that comp, FMLA, and ADA are entwined, and ultimate decision makers need to appreciate that fact, and that if they can't make if they can't handle the nuances and subtleties, that you're providing a subject matter expert, whether it be internal or external, who can help them make those decisions.
So I think that is an excellent point. And I do see that, Jake. And I also see where you have a leave administrator, a third party administrator handling the FMLA, but they're not privy to or understand how the ADA should interact. And the employer is not stepping back in to manage those communications. Or the employer thinks because I have a TPA, I don't have to bother with any communications. And then we find ourselves with documentation that is going to be problematic before the EEOC with any charge and then court. So I see that routinely. I also see where the TPA is not necessarily keeping the employer, human resources, up to speed, and they don't see what's coming across. So I can't stress that enough. I'm not sure that that's actually worth it. I am convinced that the employer is better off having somebody in-house that does this so that they can control it better. There are all kinds of tools that can help them do it. And I have not been impressed. And I've looked at a number of different TPAs and how they handle things, and I've not been impressed with any of them.
Yeah, I think when I was in-house, we took it in-house at Family Dollar. And one of the reasons is when you ask your TPA, what's your turnover rate on your frontline communicators with my employee set? So what's your turnover rate? You'll hear numbers like, well, I don't know, about 75% a year, 80%
That is
a year.
excellent. What a great question.
Yeah, and then you're like, okay, now I know what you get what you pay for. Okay, your monthly fee is really reasonable, but now I know why. Because some kid named Joey, who just dropped out of school from college, is now working as the communication person on my leave administration, and that's why we're getting approved, denied, approved, because Joey's just not the sharpest knife in the box.
Oh my gosh.
Yeah.
Oh my gosh.
Yeah. And so the last thing I want to talk about kind of along on this train is misclassification of managers or team leads. I referenced earlier that when I was at Family Dollar, we litigated whether or not our store managers were exempt employees. It was very costly litigation. I think we made great strides to fix those things, but the issue is very near and dear to my heart as a plaintiff's lawyer. So when I hear that we've got somebody from a chain retailer or a chain restaurant and there's a manager and they're talking about their pay, my little antenna goes up, because what I continue to see is, above the store level, there's always some district manager. And because of texting and email and other forms of, this quick communication, they are managing remotely these stores. And they can, they'll come into the stores once or twice, or the restaurant once every 3 weeks, leave a punch list of tasks for folks to perform. In these chain environments, the managers they're all getting kind of consistent guidance because they want a consistent brand experience for people that go into these chain environments. And then when you start digging into the text and the emails, these district managers are managing remotely. And at the end of the day, you've got a store manager or a restaurant manager or even a department manager. They're really just a working foreman working next to that hourly employee, and they themselves are not exercising any true managerial duties. And that third prong of the test, the primary duties test, that's where the rubber's going to hit the road. And it's really easy to lull yourself into a false sense of security, because the Biden administration was going to do a lot of things with these administrative exemptions, the white collar exemptions, to make it harder to satisfy them. We know the Trump administration is not going to follow suit, but you still got the primary duties test. And if you're not making sure that your district managers or your senior leaders understand what that really means, you could create some really bad wage and hour situation. And what I always, when it comes to wage and hour, if you screw up one, you're screwing them up all. I mean, it's just that easy. Multiplication is a big power in wage and hour litigation. And I have a client right now who came in, showed me some emails, and she worked in a chain restaurant, and basically her district manager told her, you know what? You simply can't handle it. So why don't you just run the fry station? Okay, and let me run the store. So you just worry about cooking and I'll worry about managing. Well, that's fine, but the young lady's knocking down 60, 70 hours a week and she's not getting paid any overtime and she's not managing anything. So they might have a little costly problem on their hands. And it's driven by frustration with my client who probably might not have been the strongest manager. Well, if that's the case, address the lack of managerial ability. Don't turn them into an hourly employee and leave them in place to work 60 hours or 70 hours a week with no overtime pay. That's the last thing you want to do.
So before we move on, I want to pose a question to you, Jake. Lisa has asked, do owners who manage their business and take a salary qualify for exemptions?
Well, I guess that's
yeah,
yeah. So I mean, I think you're okay because I mean, it's when I was at the dollar, what we always talked about was risk triage. How much risk can we bake in? And I would say in that scenario, the owner's never going to sue the business, so you're probably good. You know, you're probably on solid ground. You're not going to be called but to account, even if what they're doing should be paid hourly and you just pay them a salary. But if they're an owner, you're probably on solid ground that you don't have to worry about a risk.
Right. And so I think too, this also goes back to, would you agree, the primary duties test? So let's say it does get challenged. If it's an owner and they are getting paid a salary and they meet I would say in this situation, either the administrative exemption or the executive exemption, then they are probably considered exempt anyway. But the minute you start paying an owner a salary, they become an employee of the entity, which is separate than their relationship as the owner and legally.
Yeah.
And
once you allow that pay to fluctuate because of the hours worked, then you just destroyed the salary basis prong of the white collar exemption. And it doesn't matter what management they're doing. If their salary's not been consistently paid on a true salary basis within the legal definition of how you pay somebody on a salary basis, then you've destroyed the exemption regardless of the duties. So, I mean, if they're an owner, if you're going to pay them a salary, just pay them a salary. And by virtue of the fact they are an owner, I would speculate you probably could show that management is their true function in that entity.
Great question, though. And we've had several good questions, so keep them coming. So I have a slide, a two-paged or two-slide of points that I have developed over the years of helping employers navigate termination. And so one of the first things that, and I will say, HR folks, the ones, you're here, you're attending, you are all saying this already about documentation. And I know you struggle with getting your folks to document because you all tell me that. And so I acknowledge that this is information you already know, but it is a good thing to conclude in your training with managers. So, before terminating, is the employee going to be surprised? I had an employer call me one time. They wanted to terminate this person that they had worked with for a while, and they'd done no documentation. She was highly paid, and these were the top level management / owners of the company. They're like, no, we've got to terminate her. And I said, well, have you written her up? Have you disciplined? No, we haven't, because we're just too nice. And I said, that's maybe not nice. Like, maybe the nice thing to do is we give employees chances to succeed. And by that means we are communicating with them about what they need to be doing better, letting them know, and communicating in a way that's clear. I think Jake would agree there are so many times when an employer thinks that they have communicated clearly to their employee that you're not doing what we expect, you're not meeting our expectations. And then I read the review and I'm like, not seeing it, not seeing it. I read the warning and I'm like, oh, where's the part where we say, get with the program, right? And I'm obviously being too direct there, but you have to do that, right? And I like to see if someone's not meeting expectations, they should get a needs. And in situations, there's always a place where you can make comments that we can rely on and to defend decisions that say, hey, you didn't do this right, you didn't do that right, we expect this, we need to see you improve in this area. It's hard to do, takes courage, but it is actually the best thing to do all the way around to help the employee succeed. And it's going to possibly keep you out of having to talk to Jake or me later down the road, because the EOC does read what we provide as far as documentation. So does the Department of Labor, so does the Unemployment Commission. And if it's there, that is less time for managers and employers to have to spend testifying and giving affidavits and depositions. So exceptions to whether an employee is surprised about being terminated would be rare. And I will say every employee that's getting terminated, well, not every, but many act like they're surprised. Well, that's sometimes just the way they act. But if you have documentation that they've been told, it doesn't matter. You don't need them to agree with you. You've got documentation and you know they're not surprised. But those discussions need to happen. And the documentation, sometimes people don't listen until they get a warning. So the documentation needs to happen. If you're dealing with professionals, do a PIP, whatever, but do it. Or emails. Hey, we really need to see you improve in this area when we're dealing with professionals. Just let's have something in writing, and let's have several things. The more protected status, we're talking 3. So the exceptions to this would be rare, right? So egregious violations, standards of conduct, or violations of policies, or severity of a standalone incident. The exception would be the employee gets terminated for stuff that falls into these categories. Dangerous conduct, threatening, harassment and discrimination, etc. But otherwise, if it's about performance and even about conduct that isn't dangerous or threatening or intimidating, we're needing to have some discussions that are documented. Next slide. Then is this, after we decide the manager says we've got to terminate this person, and we look at the documentation and talk to them about that, is this consistent with previous terminations? And that's where HR pops in and has to think about it. Because you can have inconsistency across departments because of different ways folks manage, but the employer legally is going to be judged by what they did across the board. It's not going to be by department. And the EOC will ask questions like that. Tell us all terminations for same or similar conduct in the last 2 years, and all that engaged in the same or similar conduct in the last 2 years that weren't terminated, and why. And it's rarely because of somebody's protected status. But invariably, if we can't prove the negative, then that's the conclusion. And certainly that will be true before a jury. So remember, when we're looking at consistency, we're evaluating in the context of discrimination, i.e. protected status and harassment, safety violations. Did an employee make an allegation of a safety violation or whistleblowing? Employees, especially the ones that are not doing well and not following this documentation where you're encouraging them to perform better, they have a sixth sense of when they're about to get terminated. I can't tell you how many times it happens. The employer is planning to come in and terminate, and before the employer can do it, the employee makes a claim and says, oh, there's a safety violation, or this happened, or I've been discriminated against on the basis of such and such. Well, the documentation in the personnel file, if it's there, is going to protect you. If it's not there, then we're going to have to play a little bit of a waiting game and do what we need to do. So those are the types of things that should be thought about as well. Is this person disabled? Is this person, have they communicated the disability? Have they asked for an accommodation or retaliation for any complaints that have been made in recent times? If the documentation is there, that's going to defend us. If it's not, then, how are we going to prove that this was not actually what the employee is telling, any of the agencies, but instead this person just wasn't performing or what have you. And again, termination always needs to be explainable as a legitimate business decision. That is a legal buzzword for these harassment discrimination actions. And it simply means you've got to be able to describe and explain why it was important that we terminate this employee. So we can show that it was not subterfuge for discrimination, but instead this was the legitimate business decision. And there's lots of reasons why that would be the case. So important things to remember, a checklist really, before termination happens. Next slide. All right, independent contractor.
Yeah, so another area that I see that I just don't understand is, 36, as point B talks about, independent companies more and more are classifying workers as independent contractors. And I get the why, right? You don't have to pay any overtime. You're shifting the tax liability onto these employees. You feel like it gives you greater flexibility. But they'll have these independent contractor agreements, and in them will be a non-compete provision, which to me can have the ability to destroy your ability to designate someone an independent contractor, because as is outlined in C, the test, it's an economic realities test. And it just says, okay, essentially, let's look at the facts, let's look at the totality of the circumstances. And was the individual who's trying to be deemed an independent contractor truly in business for themselves, or were they so dependent on the company that they're an employee? And it's a flexible test. It says, let's look at the sum total of the facts and circumstances. But if you have someone sign an independent contractor agreement that has a provision that says, if you leave here, you can no longer perform that profession that you performed for us, that reads more like they're an employee. And I think, I know if you do this, you're saying, well, I have this protectable economic interest. If they come and work for me, they're going to gain knowledge about my client list or some trade secrets. Well, I think there's confidentiality provisions, right, that can accomplish those same goals, but a blanket non-compete for 2 years. So you might be, you're working as a, and it's also in these jobs where they're working with their hands. So it's not like what you traditionally think of as like a computer programmer as an independent contractor. I'm talking about a guy who goes around and turns a wrench fixing machinery, but he's an independent contractor. But should he leave for the next 2 years, you can't be a mechanic because you'll be competing with me in my business of fixing machines for others. To me, companies put themselves in almost a no-win situation trying to explain how that person that they deemed an independent contractor really was independent, but because the facts really screamed they were an employee. And if they're an employee and they've been working a lot of hours, you've just committed a wage and hour violation. You've got problems with the tax folks because you hadn't been paying the employment taxes on them. You're just creating a lot of problems for yourself. So again, I think this is another area where the trend is to have more and more independent contractors in your workforce. But are you truly partnering maybe with your outside counsel to craft a defensible independent contractor agreement, as opposed to go online, use AI, chat GBT, and try to draft your own agreement, and then you're just ginning up problems for yourself that you can't defend later on. So this is another area where I see continued problems on the part of employers.
And Chris,
All right.
good time for.
Go ahead. Great. Does your organization have an employee handbook? Great. 83% say yes, 14 say no, and then 3% not sure. So I would say, and I would think in this day and age, most do, if you have 15 or more employees, there are policies you're required to have. And so at that point, once we have to have policies legally, it makes sense to collect them in a handbook, because if they're floating out there separately, there are several different arguments employees can make about why those wouldn't apply. And ambiguities are always going to be construed against the employer in that situation because they're the ones that put the policies out. So you combine them and then you put the South Carolina at-will disclaimer on the top so that it doesn't create a contract, that's been held to be in Smalls versus Springs. An employee handbook can be a contract if you don't have the at-will disclaimer on the first page that meets the all capital letters, bolded, underlined 12 font requirement of our statute. You got to have it there. So it's a great way to protect, right? And then make sure the policies are compliant. And one of the things Jake and I were talking about is so often we see a handbook get produced and a situation where the employer hasn't followed it. Something else we also see is handbooks that have just things in them here and there that would be non-compliant with written law. And there it is in black and white, and it's hard for an employer to argue against it. So, you start off at a disadvantage. I do a shout out to Katie Busby. She's on our team, and she is a great handbook reviser. But it's something that needs to be done annually. So, Jake, anything you'd want to add here?
Yeah, I mean, I think that what I would encourage employers to do is, especially now that many handbooks are on a portal. Okay, the days of the printed handbook are over. Now it's on a portal. You keep updating your portal. HR loves to update that portal, change the policies. It's a living document, but you're not letting your managers know it's been updated. So, do your managers even know what the handbook says? Are you doing anything on a yearly basis or periodic basis to make sure they know what's in the handbook? Because I think I do see a lot of confusion between, the handbook's been updated, but we're not doing anything to ensure our people know, or the people who are supposed to be enforcing the handbook know it's changed. Back in the day at Family Dollar, I'd go into a store and I'd find the current version still shrink wrapped, holding up the loading door so it wouldn't close when they were bringing the truck in. They were using it as a door chock, okay? But now it's even harder because there is no paper handbook. It's on a portal. And it can be changed so often on the portal. I would encourage folks to say, do we have some kind of internal audit function that lets folks know it's been updated, and ask them to please educate themselves so that everybody's on the same page about what are we promising people? Even if it's not an enforceable contract, these handbooks, you get enough HR folks in, not to hurt anybody's feelings, but next thing you know, you're promising the sun, the moon, and the stars and this great treatment. But if you don't live up to it, it can rub a jury the wrong way and put you in a bad place in a trial.
Next slide. All right. So top of the list is documentation, and we've talked about it all the way through. We've beaten this dead horse, and we'll beat it a little bit more. Candid and honest evaluations, training. If you have training, make sure that that is documented in the employee's personnel file by the specific training. So many times they say, I'm not trained. Well, there it is in the documentation where they were trained. They have a record where they attended it and signed off. If you have investigations, make sure that those are documented. In fact, if it's a harassment, discrimination, retaliation, there's a very specific EOC guideline about what the documentation should look like. But any investigation where there's going to be any analysis later of why somebody was let go, or just an employee using that situation to glom on to any claim they have, if it's not documented, it didn't happen. Paralysis by analysis when it comes to the difficult mouthy employee. I'm going to throw out here that I do see when we're dealing with someone who is definitely either mouthy or clearly trying to manufacture a claim, employers kind of freeze because they don't know how to communicate, and possibly also let them get away with more, which then creates more of a problem when you finally do act as an employer from a liability standpoint. So deal with everybody the same way, address things current, when it shows up, document it, and deal with it regardless of who you're dealing with. And if it is someone who is clearly trying to game the system, get legal advice on how to communicate, how to document. I've done that for clients for a year before we let someone go when someone was playing tricks. And, so that's what I would pop in and say on that one. Next slide. Discipline. Here are some of the issues: waiting too late to document, not documenting verbal warnings or counseling sessions. Why not document those? Employees feel better when they see something called a verbal warning or counseling. But if the employee if it's in writing and it's been signed by the employer and signed by the employee or a witness present who says employee refused to sign, but this is what they were told, it's all the same to me. It's all the same to Jake. It's real documentation. And any documentation always include termination failure to improve could result in termination. Put it in there. The EOC will say, did you warn them they would be terminated? Just put it in there in every one of them. Save email and text communications. Somebody on the chat said, what about Teams conversations? or any of those other electronic programs that companies use for communication. Save it all, save it all. And the question was, can it be discovered? Yes, which is why if you're going to have things that are not retained, you need to have written retention policies that comply with the employment laws and then follow it, right? And so if you're going to not automatically save certain types of communications, then do it pursuant to a written retention policy. And that includes an email retention policy. I'm speaking generally there. There's always, rules specific to the industry that have to be followed. But other than that, in litigation, the litigation specialists come in and they do a search of your database, and they will find things that you may or may not realize were out there, and it has to be produced as if it's relevant to the litigation, number one. Number two, if they don't find it or someone says, I don't have it anymore, then sanctions for failure to maintain the electronic documentation can be worse for a client than even the actual liability for any underlying claim. Next slide. We're almost done. Personnel file. I've already said it, so I won't say it again, but that can help or hurt. And next slide. I think that's it. So, Jake, anything else you would add?
No, I would just say that, I think what you mentioned about, if you don't have a document retention policy, you need to have one. And if you've never heard of a spoliation order, ask your lawyer to explain what that means. Because if you don't have a document retention policy and you're not sophisticated about what you keep and what you lose, if you're in litigation and there's some information you're supposed to have and you don't, and you deleted it at the wrong time, there's a jury instruction that can be read to the jury that says, had that information been present, it would have been helpful to the plaintiff. It's a plaintiff's lawyer's dream to get a spoliation order that the company deliberately destroyed documents. When I was at Family Dollar, my second day on the job, I found out about a 27 plaintiff race case in the Trans-Mississippi, and we had a spoliation order over the destruction of personnel files. And it's not a good place to be. Okay, you end up settling those cases and you end up paying a premium. So if you don't have document retention policies, especially with your email or your text or your Teams, you really need to have one, because that can also provide a lot of cannon fodder for a plaintiff's lawyer.
So this has been invaluable, Jake. Really appreciate you coming on and
My pleasure.
And having this conversation. I think our attendees, we had over 100, and they were on today and asking questions. And I just think it was so invaluable. So thank you so much for joining us and sharing this very helpful information. And everyone, next month, we're going to probably talk about the EEOC the Department of Justice and EEOC's technical guidance on what is harassment and how DEI is impacting that, to give everyone an update on what's going on with the DEI as it pertains to harassment discrimination. So look for the announcement for that and sign up. And thank you so much for attending. Jake, you're getting lots of claps. Do you see them?
Thank you. I appreciate that, everyone. I enjoyed being with everyone today, and enjoy the rest of your week.
Thanks for joining this webinar presented by Hainsworth Sinclair Boyd. To learn more about the firm and its services, visit hsblawfirm.com.